my enormous pleasure to welcome you to this evening's event, our annual faculty lecture. And this is a much cherished departmental tradition to come together at the end of the academic term and hear from a colleague about their ongoing research. And also indeed to celebrate our many good fortunes together. So the plan for this evening is that after the lecture and the question answers, we'll stay here for a bit longer and we'll distribute the annual teaching awards from 21-22, and then we'll make our way downstairs for the much awaited holiday party to wind down after what must have been a tiring semester for all of us. The proceedings of this evening have been made possible by the very generous donation of Bernice Nugent, who was a student of the history department and who graduated from history in the 1930s. And as you may be aware, that many and most of our academic events and other workshops are funded by this generous bequest. The speaker today is our colleague, Professor David Parker. And David, after completing his PhD from Stanford in 1991, joined our department the very next year. And he's known to us as one of the most foremost scholars of Latin American middle class. And his first book, The Idea of the Middle Class, White-Collar Workers and Peruvian Society, 1900 to 1950, remains a foundational text on the idea of the middle class, not only among Latin American scholarship, but is widely cited in global discussions of the global history of the middle class. The book was a rich social history that in some ways established a field by showing how the identitarian aspiration of white-collar workers in Lima forged a new class identity and thereby altered the social and political culture of the 20th century society. More recently, David has made a path-breaking contribution to the cognate field or the public sphere, seen through the lens of social actors. In his most recent book, The Pen, the Sword and the Law, Dueling and Democracy in Uruguay, David focuses on the history of dueling culture, producing, to the words of a reviewer, and only one review has come out so far, an original and productive understanding of politics in history. And some of you attended a book talk recently, a book launch and a book panel in November. Today's talk draws from the book, but essentially recasts the findings and the reflections in a new conceptual frame. David has also made lasting contributions to the fields of public health, housing, and labor. And apart from his scholarship, he is one of the most successful instructors in the department, having won the Departmental Teaching Award in 2019 and the Principal's Teaching Award for Promoting Student Inquiry the previous year in 2018. Now, it is important to outline some of these achievements of a colleague before a faculty lecture and talk about the many accomplishments in an introduction like this. But these are facts that I've just said are known to you, or at least it can be very easily looked up. But I want to say a few things on a personal note. And as I think that these faculty lectures are not only a lecture, but also a celebration of the careers of our colleagues. And since arriving at Queen's, I have always thought of David as the central column of this department. Indefatigable and abundantly resourceful, David has always been the steady colleague that I could count on any and every issue. And for every issue, or the inception of every endeavor, I've always been able to count on his counsel, advice, and very frank and honest assessment. David Parker makes the department a better place every day. Please join me in welcoming David.
Thanks, Amitava, for that extraordinary and undeserved introduction. I'm going to, as I've said, this is something that I've done before in work that I've done, that I wrote something, and then after it I looked at it and I said, well, I want to think about this a different way. And this is sort of taking previous work, recasting it, but also expanding a little bit. As you'll notice in the title there, I've crossed out the "in a small South American country." It's got a strike through. Because as I was writing this paper, I kept bringing in examples from other countries, and it turned out that Uruguay only ends up playing a small or sort of minor role in today's talk. But I'll start with Uruguay nevertheless. Roughly a decade ago, in this faculty lecture, I presented a microhistory from that country, a sort of a bizarre case where an assassination attempt ended up being interpreted by police, judges, and opinion in general as a duel, despite not having been a duel at all. So I hesitated when Amitabh asked me to give a faculty lecture for a second time a decade later, because I wondered if two lectures from the same broader research project were justified. But I also had an idea that I was already working on to explore two important concepts in scholarship on the law. And those concepts are legal pluralism and interlegality. Now, I understand perfectly well that I'm likely taking the romance and swashbuckling excitement out of dueling as a lecture topic, running a genuine risk of achieving the near impossible, which is to make the duel boring. But I hope to replace the lost swashbuckling with some hopefully thought-provoking speculation about larger questions in legal theory and legal history. And it's hard to imagine a bigger question than what qualifies as law. So this talk is in 4 parts. And the second part is the longest, so don't worry if 35, 40 minutes in, I'm still in that second part. I think I've timed this out. So four sections, and you can see them right here. Okay, so let's start with the first topic. The idea of legal pluralism has been around for a bit more than a half century and has achieved a status as an established subfield of legal anthropology, legal sociology, legal history, and critical legal studies. Legal pluralism has had its own specialized journal for 40+ years, the Journal of Legal Pluralism and Unofficial Law, which last year changed its name to the Journal of Legal Pluralism and Critical Social Analysis because of the times that we are in. But for those who might not be familiar with the concept, legal pluralism can best be described as both a subfield of study and a critique of prior legal scholarship. Its central tenet is that law should be seen wherever authorities can be found imposing normatively based decisions. This comes from a book from the 1950s. In one of the most influential articles ever written in this field, entitled "What is Legal Pluralism?", a man named John Griffiths in 1986 distinguished between weak and strong versions of legal pluralism. Former NYU anthropologist Sally Engel-Mary called it a distinction between the old and the new legal pluralism. The weak version focuses on deliberate carve-outs, where elements of folk, customary, ecclesiastical, international, or other non-nation state forms of rulemaking are recognized as law and given the power of law by nation-state governments. These were the first contexts in which legal pluralism was empirically studied. That's why Mary called them the old legal pluralism. The classic and most written about cases of legal pluralism come from colonial situations. especially British indirect rule. This helps to explain why the Journal of Legal Pluralism and Unofficial Law was the institutional successor to an earlier journal called African Law Studies. In the typical narrative of the relationship between indirect rule and legal pluralism, British colonial authorities treated the customary law of native inhabitants much the same way they conceptualized unwritten common law in Britain. At the same time, much of the literature, and it's extensive and very good, makes the case that what the British chose to accept as customary in their colonial possessions was often as much a British invention of local practices as it was a recognition of them. Other forms of old or weak legal pluralism, where state law formally conceded some jurisdiction to other non-state forms of law, might include such things as deference to international conventions and treaties, such that supranational law, as for example with the European Union, supplants the nation-state's law in particular matters, or bilateral extraterritoriality agreements that allow foreign immigrant colonies to live, or multinational corporations to operate under the laws of their home countries. Carve-outs that enable religious communities to apply religious law for their own members. In some instances, obviously the most famous example of this is Sharia law. Indigenous peoples' decision-making processes recognized and validated by state law as legitimate for certain purposes. And this is an example that has accelerated in recent decades, both here in Canada and around the world, following the explosion of the global indigenous rights movement since the run-up to the 500th anniversary of Columbus. And I'm sure that there are other great examples that I'm not mentioning. What is key here is that they are carve-outs where states choose to cede some of their legal authority to non-state law or to the laws of other countries or international bodies. Now, the strong version of the theory of legal pluralism, which is also the newer and more radical version of the concept, I think is more interesting and more relevant to what we're talking about here. And it goes something like this. Law is everywhere, and nowhere in the world does the state have a monopoly over law-like processes of norms enforcing. Hence, we need to stop seeing state law as unique in kind when those law-like processes exist in innumerable spheres of daily life. John Griffiths, who I mentioned earlier, contends that the belief that nation-states are the sole source of law, or what he calls the ideology of legal centralism, is a proscriptive theory of what the law ought to be, masquerading as a descriptive theory of what law actually is, with the purpose of legitimizing the hegemonic claim of the modern state. So this strong version of legal pluralism is bolstered by a couple of observations about society and the systems of law that operate within it. Legal pluralists emphasize how empty, how utopian is legal centralism's belief that the institutions of state justice have the capacity to regulate all the important areas of human intercourse. Strong legal pluralists argue that state law has a very limited reach, and that it's a recourse accessible to only a fraction of the population, that it regulates only a small percentage of human interactions. At the same time, while strong legal pluralists recognize that the jurisdiction of state law has inevitably expanded with the modern nation-state formation and the increasing regulatory scope of governments, they reject the idea that the extension of state law comes at the expense of non-state rules. Legal pluralists don't see the universe of what is legally regulable as fixed in size, such as that the domain of non-state law must shrink as the domain of state law grows. Rather, state law can expand its reach while other non-state forms of legal ordering simultaneously expand, the growth of one nourishing the growth of the other. So examples of law outside the domain of nation-state law might include all kinds of things. Educational institutions with their own disciplinary norms and procedures, membership organizations that have regulatory power over their members, administrative boards and arbitration procedures and labor relations, the bylaws of labor unions and even history departments, user agreements or consumer rights and duties granted by user agreements or warranties or other agencies, that create contract law every time you click on a piece of software after not having read the thing you were supposed to read. Rule books that govern the playing of sports. The possibilities are nearly intimate, and the strong version of legal pluralism says that all of those things should be considered law because they regulate human behavior the same way that state law does. And this strong version of legal pluralism is far more controversial than the weak version. Critics argue that if law is everywhere and all norms are law, then the concept of law is rendered pretty meaningless. In the words of Sally Engel Mary, why is it so difficult to find a word for non-state law? Where do we stop speaking of law and find ourselves simply describing social life? Is it useful to call these forms of ordering law? In writing about legal pluralism, I find that once legal centralism has been vanquished, calling all forms of ordering that are not state law by the term law confounds the analysis. The literature in this field has not yet clearly demarcated a boundary between normative orders that can and cannot be called law. Brian Tamanaha accuses strong legal pluralists of using the word law to endow non-state rules with the prestige of state law, when state law should in fact be recognized as having unique characteristics in being backed by the state's coercive power and enjoying the nation-state's symbolic legitimacy. Legal pluralists counter that nation-states are by no means the only institutions that exercise coercive power and enjoy symbolic legitimacy. So just about everybody eventually makes it back to one key question. How do we distinguish rules that we call law from rules that are just rules? And there's endless disagreement on this, but the best way to conceptualize the distinction between law and just rules is not as a firm boundary, but more as a sort of sliding scale with ideal types at each end. So I've distilled from the literature 7 essential questions to ask to locate a particular normative system on that sliding scale continuum, with definitely law at one end and rules, but probably not law, at the other end. So let's start and go through the list. Are the rules written and codified? Lon Fuller, in a pretty famous book called The Anatomy of Law from 1968, proposed the distinction between interactional law, the rules and norms that arise out of and end up governing all kinds of social relations, and enacted law, which has been set down explicitly by some authority. Gerald Pastima uses alternative terms, implicit law versus made law, but it's the same idea. Second question, are there dedicated authorities charged with the duty of interpreting the rules and applying them to individual cases? Courts, judges, are those authorities institutionalized or are they ad hoc? Do these authorities, point 3, follow standardized procedures that are themselves governed by explicit rules? In other words, are there norms about the application of norms? And this question builds on another famous writer, H.L.A. Hart, who in The Concept of Law, 1961, talked about primary primary rules versus secondary rules. The secondary rules being, for example, things like rules of evidence or rules about burden of proof. Are there rules-based procedures for deciding disputes over the interpretation and application of the rules? Are there rules of procedure, are these rules of procedure themselves codified? Point 4, do precedents from one case apply to subsequent cases? Point 5, are there rules-based procedures for modifying or reforming the rules? Points 6 and 7 are truly central. How much coercive power do the norms or rules have to punish transgressors? And if these non-state rules overlap in some way with state laws, which takes precedence when they clash? And as I will go through in just a minute, the rules that regulate dueling, I was finally going to make it back to dueling, fall on the definitely law side of the scale by all of these criteria, save one or at most two. And even though a great many have remarked on the dueling codes, the dueling manuals' law-like appearance, and a handful of scholars have traced both their borrowings from, and to a lesser degree, their influence on nation-state law, no one else that I'm aware of has analyzed the duel as an actual system of law in a context of legal pluralism. So that's really what I'm trying to do today. Now, it's perhaps not surprising that nobody's done this. I mean, the vast majority of the scholarship on dueling sees it as a social practice, reflecting a set of cultural norms, ideas of masculinity, honor, aristocratic distinction, and so on. Plus, it's difficult to see the duel as law when almost everywhere it was a crime from the viewpoint of state law. Several authors have remarked on the dueling code's law-like appearance, and those who have remarked on it have hypothesized that it was precisely because dueling was a crime that its aristocratic advocates felt the need to legitimate themselves by mimicking the language of law in the codes that they themselves crafted. The closest approximation is that people might see the duel as a form of customary law, destined to be eclipsed over time by state law. I've used that terminology myself, customary law. But the more I've looked and thought about it post-publication of my book on Uruguay, the more I've come around to the idea that the honor codes should not be described as like legal codes. They were legal codes, with characteristics quite distinct from other forms of customary law. However, if you conceptualize the duel only as the moment when two gentlemen went at one another with pistols or swords, what I'm saying here is a really hard argument to sell. In order to make the case that the duel functioned as a system of law, we have to understand how the dueling codes, routinely described as the laws of the duel, the laws of honor, or the gentlemanly laws, how they functioned in their entirety, from how they defined offenses against honor, to how they adjudicated disagreements over whether or not an offense against honor had been committed, to the procedural rules that led from an alleged offense to some sort of resolution, sometimes in a duel, but very often not. So looking at this slide, focus not on the foreground of the picture, but on the background, the people who surrounded the guys with sabers. This is what I'm really talking about today. Okay, so let's go through this a bit, thinking in terms of this sliding scale continuum between definitely law and probably not law. First, written text. Are the rules written and codified? The norms and rules of dueling did exist in fully codified form, in published dueling codes, and there's nothing accidental about Bruno de la Horie naming his 1906 code the laws of the duel. And many other codes did the same, including the Uruguayan code on the right, which is from the 1950s, actually. Although there were some points of disagreement between the many different dueling codes written in different languages and different countries, those were relatively minor in comparison to the fundamental principles on which all the codes agreed. And those shared principles were both normative and procedural. So I'm going to just go through really quickly. You're not going to have time to actually read these slides, but just sort of get a look at them. The 20th century, turn of the 20th century Spanish dueling code on the left from the Marqués de Cariñana. It functions as a criminal code in that it identifies certain crimes over which the code claims jurisdiction, and then it outlines an entire procedural system for dealing with those crimes, exactly like other codes of criminal procedure. You know, Article 1, Article 2, Article 3. This is the Uruguayan Penal Code, Article 1, Article 2. They're written virtually in identical fashion and often embody many of the same principles. This legalization of the dueling codes, most people say, started with the most famous of all dueling codes, the one of Count Chateaubriand, The Art of the Duel, 1836, which was the first real innovator in this legalizing direction. And as you can see, he quite explicitly says what he's doing. If the Code of the Duel stands outside the law, if there can be no code but that's sanctioned by statute, let us not hesitate, nevertheless, to give that name to the rules imposed by the rules of honor. And subsequent French, Italian, Spanish, Latin American codes all followed this model. Okay. Second point. Authorities charged with interpreting and applying the law to specific cases. Everyone knows that essential to any duel are the seconds, but there's much about what seconds were charged with doing that is less well known. Seconds were essentially lawyers for each party, appointed in writing via a dueling power of attorney. It was called in Spanish a carta poder. And this was sort of the way in which you enlisted formally your seconds. Seconds were charged with a triple duty, as they were advocates for their client, they were negotiators who met with the seconds for the opposing party, and they were guarantors of whatever agreement the two sides reached, so that it would be faithfully adhered to. What were they negotiating? Things like, who is the offender of the two men in conflict? How grave was the offense? Because that had implications for who gained the right to choose weapons if things ended up going to a duel. And the job of the seconds was seen as so important and so central to the whole edifice of dueling that there are actually even manuals just about the duties of seconds. The honor codes demanded that seconds function as conciliators, to work to avoid a duel or to minimize its severity if solution of the conflict was impossible. And because of that key conciliating function, they were not, like lawyers, subordinate to the will of their clients. They had full power to rule against their clients' wishes, refusing to allow a duel or to proceed, or demanding that their client issue an apology if, in their judgment in conversation with the opposing seconds, if that led them to that conclusion. One core principle of dueling law was that the client had to abide by their second's decision. So this was essentially binding arbitration. An additional law-like aspect of the second's negotiation process was that it always resulted in a written record, duel or no duel. was written record. They were called the actas in Spanish, the procès-verbaux in my mangled French, relazione in my slightly less mangled Italian. But above the 4 seconds, there was actually an appeals level whenever the seconds could not come to an agreement amongst themselves. The appeals courts were called honor tribunals or honor juries. In their most common form, they were ad hoc. One set of seconds named one member of the tribunal, the other set of seconds named the other, and then those two agreed on a third. And the honor tribunal would consider the written actas submitted by the seconds, setting out the issues in dispute and the positions of the two sides, and after study, often consulting with one or several of these dueling manuals, these honor codes, and considering precedents, the honor tribunal issued their ruling, which was called in Spanish a fallo, or a laudo, the same words in Spanish as a judge or court's ruling or verdict. So that's the second point. Point 3, standardized procedural rules. The dueling codes establish detailed, explicit, and highly standardized rules and procedures. Put a dueling code alongside a code of criminal procedure, and they appear in every way to be doing the exact same thing. But the rules themselves diverged in some significant ways, which helps to explain why men seeking to protect and defend their reputations so often chose the laws of the duel over the laws of the state, a point that I'll get to in more detail shortly. The dueling code's objective was never to punish a criminal, but to, quote, repair the harm that had been caused by the offense that originated the challenge, which is almost word for word the definition of restorative justice. You know, repair the harm. Even if things did escalate to a duel, that restorative justice rationale continued to hold because duels did not, in theory, have winners and losers. No one was proven right, no one was proven wrong. Rather, as both men faced death in conditions of strict equality, both gave witness of their disregard for anything other than their honor. And of course, the procedures in the honor code led to infinitely quicker resolutions than the state legal system. Seconds were named, seconds met, seconds ruled. Maybe if it was a complicated case, it went up for appeal to an honor tribunal, and the duel, if it happened, had to happen within 24 or at most 48 hours. Generally, honor tribunals were, as I said, ad hoc rather than permanent, but there were exceptions, such as standing honor tribunals that were established by and for the armed forces, or among journalists, among the press. And that's another point that I'll return to a little bit later. So what kinds of disputes made it to this appeals court level? Tended to be complicated cases involving multiple escalating mutual offenses, and especially cases where one side refused to recognize the legitimacy of the other side's accusation that their honor had been offended. The classic and frequent example here was when newspapermen, having been challenged to a duel in response to something they wrote, responded that they were legitimately reporting true facts in the public interest, and that the only purpose of the challenge was to intimidate and censor the free press. Now, this interesting point. These exact same conflicts could be, and sometimes were, vetted in the state's legal system, using provisions and procedures dealing with libel, calumnia in Spanish, insult, injuria in Spanish, defamation, and other crimes against honor and reputation, crimes that were on the law books. The literature on legal pluralism is filled with discussion of the phenomenon of forum shopping, when two distinct legal regimes have overlapping jurisdiction. Conflicts over honor and reputation were one such instance. And the documents are often quite explicit about individuals knowing they have a choice between seeking prosecution of alleged crimes against honor by what they call the via legal, the legal road, or seeking satisfaction by the via caballeresca, the gentlemanly road. Most of the time, people in public life chose the latter. There were highly practical reasons why forum shoppers preferred dueling law to state law when honor and reputation were at stake. For example, people believed that the presumption of innocence in the state legal system enabled defamers to hide behind pseudonyms and to employ indirect allusions for the purpose of deniability, and that bringing issues of insult or slander to the courts only spread defamatory lies more in what is nowadays known as the Barbra Streisand effect. And if you haven't heard the term Barbra Streisand effect, Google it afterwards. But in dueling law, the person accused of having impugned another's honor, and the person who was thus challenged to a duel, was the one on whom the burden rested to prove that he had had no intention to offend. Often all that took was a word, a statement retracting the insult, or otherwise manifesting respect for his counterpart. A transparently insincere apology might be cause for social opprobrium, but a sincere apology was actually the most sought after outcome, the outcome that seconds were instructed always to seek first before permitting things to escalate to an actual duel. So point 4, precedents, jurisprudence. For a system of rules and norms to fall on the definitely law side of the sliding scale, some system of jurisprudence needed to exist so that past precedents were applied equally, and so that they were not applied in an arbitrary way in subsequent cases. Dueling jurisprudence came in a couple of different forms. Came in the form of published expert commentaries on the dueling codes, which almost perfectly reproduced the form of expert commentaries on laws and legal codes, commentaries typically known in Spanish as concordancias and anotaciones, which are abundant in countries that live under the civil law tradition. But jurisprudence could also take the form of what we should think of as dueling case law, where specific prior negotiations between seconds and the actas that those negotiations had generated were occasionally preserved, compiled, and even published in books like this one, Cesar Vial's Jurisprudencia Caballeresca Argentina. And when there weren't books like this, nevertheless, the important celebrated precedents were things that people collectively remembered. Are there rules-based procedures for reforming the rules? Here is one place where dueling law does not fall on the left side of the scale. Although the normative principles and general procedures of dueling law were well understood and little disputed, as opposed to the application of dueling law to specific cases, which is a different matter, dueling law did not have a single canonical text that could be, that there could be standard procedures to amend, nor did each jurisdiction develop a single national dueling code, although there were efforts in that direction. So these are all of cases where the writers of these codes were trying to get these established almost as like sort of the canonical national codes. But dueling codes could be written by anyone who felt like writing one. and did contain different perspectives on certain fine details. The embrace of any particular code was dictated by the book market. But what kinds of details distinguish one code from another? Things like whether or not they permitted duels with certain dangerous weapons or irregular conditions. Or whether, and this was one that came up a lot, whether the publisher of a newspaper was responsible for answering challenges arising from pieces that appeared anonymously in his paper, or whether it was always the author's duty to come forward. What to do in the case of somebody who just for some reason couldn't duel, for advanced age or something like that. There were these minor fine points. And the only procedure for altering dueling law would be to write and win readers over to a new honor code. And yet the drafting of new honor codes often did follow procedures that looked a lot like law. Proposed honor codes resembled proposed legal codes. They were pre-circulated for comment and endorsements the same way that draft legal codes were. They thought about the process in that way. Okay, point 6, the coercive power to punish transgressors. The dueling codes obviously were not backed by the coercive sanction of the state, relying instead on social sanction. But social opprobrium could be consequential, a lesson learned by the Uruguayan congressman who earned his expulsion from Congress and loss of his parliamentary immunity in 1883 because he backed out of a duel that his seconds had agreed to on his behalf in violation of the principle in the honor codes that once you engage seconds, you submit to their authority and accept their decisions without question. Minor violations of dueling law, such as a challenge for a frivolous, unjustified reason, were sanctioned within the norms of those dueling codes. Seconds had the right, for example, to declare the frivolous challenger not the person who was offended, even though he thought he was offended, but he would actually be determined to be the offender, and therefore he would be deprived of the right to choose the weapons and the conditions of the duel. Now, more serious violations of dueling law, such as firing a weapon before the signal to fire, or too long after, or challenging someone for an immoral or otherwise prohibited purpose. For example, it was not permitted to challenge a man to whom you owed money, for obvious reasons. These were punished by taking the matter out of the realm of dueling law and turning it over to the state's justice. So take the famous Mexican case in 1894, when Colonel Francisco Romero, having killed Jose Verástegui in a duel, faced a full-scale criminal investigation by the authorities for this act. It appears that people who would have looked the other way with a normal duelist, and who had looked the other way in many previous duels, refused to do so for Romero. Witnesses even came forward to make that investigation possible. Why? Because of accusations that Romero had intentionally violated dueling protocol, thus rendering the case not a duel, but if the allegations prove true, a murder. Which leads us to the last of the 7 questions. The relationship between dueling law and state law, and which took precedence when they clashed. Dueling law had rules, usually unstated, but in a few codes they were explicitly enumerated, about how duelists and seconds were to behave if their actions brought them the scrutiny of state authorities. When police tried to investigate or judges prosecuted a duel, dueling law called upon seconds and participants and doctors and witnesses alike to keep silent or to deny any knowledge that they might have. I opened an article that I wrote a bunch of years ago with one such anecdote. A man, this was in Argentina, a man told the policeman at his door that his brother, quote, could not see them because he was bedridden with a sword wound, but that it was an accident. He had slipped while playing with the weapon and had fallen on top of it, the blade entering his right side below the shoulder and passing through his body. The additional wounds on his hands came when he attempted to pull the sword out. In another case, a bullet wound was attributed to the accidental discharge of a pistol that for some unexplained reason had been tied by a rope to a tree and had then fallen to the ground. This raises the question of how much authority nation-state law had over duelists. According to many of the best legal experts in 19th and early 20th century Italy, Spain, Argentina, Uruguay, and other countries, although nation-state law claimed supremacy in that it defined dueling as a crime, that claimed supremacy in theory did not at all translate into practice. Here are the words of one of Argentina's most respected 19th century jurists, Rodolfo Rivarola, in his 1890 exposition and critique of Argentina's criminal code. And my quote's a little bit longer than what's up there. In the short time that the Argentine Penal Code has been in force, none of the circumstances that hinder repression of the duel have changed, confirming the opinion that in the end should prevail everywhere, that it is impossible to make the duel a crime and to prosecute it as such. In one recent duel with lamentable consequences, the police authorities of the capital of the Republic detained the duelists and demanded that they give their word that they would not carry out their intention. They promised and then went on to duel in another jurisdiction where one of the combatants paid with his life. In another duel, luckily without injury, the combatants fired their weapons seven times before the authorities intervened, and caught in the act and taken to the police station, they declared that they were entertaining themselves target shooting, and the police authorities formally accepted that explanation. Rivarola continues, the same thing happens everywhere. People try to contain the duel either by establishing severe penalties or by setting more modest penalties in the hope that they will actually be applied. Our law falls in this second category, as does the Spanish, as does the Italian, and neither among us, nor in Spain, nor in Italy, do the laws against the duel avoid being made a mockery. The duel is thus in the category of actions against which all laws are powerless. And again, the only exception to this nearly complete impunity was if some violation of the honor code turned an encounter into something other than a duel, in which case duelist omerta kind of no longer held. Think of the Romero-Verástegui duel in Mexico mentioned earlier. Cabriñana's Spanish code addressed this hypothetical where someone insisted on a prohibitively dangerous duel under exceptional circumstances, a distance closer than 15 paces, or non-standard weapons. Cabriñana saw these code violations as immediately inviting transfer of the matter over to ordinary state courts. So in a twist on the way we usually think of legal pluralism, it was dueling law that established carve-outs where it voluntarily ceded authority to state justice. But if I've convinced you that the dueling codes established a full-fledged system of non-state law with its own texts, lawyers, judges, procedures, and jurisprudence, so what? The only thing that I've done is to discover a heretofore unappreciated example of legal pluralism. I think there's more to it than that, because the case of gentlemanly law not only adds a fascinating case to the legal pluralism literature, but it also challenges several presuppositions of that literature. Let's start with the fact that the legal pluralism of the honor codes did not occur in a context of ethnic or religious pluralism, nor in a context of colonialism. There was no national minority or colonized population that was granted the use of their own law alongside state law. Indeed, one thing that makes the case of dueling law so fascinating is that its purview extended to a subset of crimes, insult, libel, slander, that with only a handful of exceptions were already treated as crimes in state law. So why did you need a second law, non-state law, here? You have with dueling law the nearly unheard of situation as well, where the advocates for this form of parallel non-state law are the exact same people who are the champions of state law in every other context. Politicians, lawyers, bureaucrats, even jurists. Some were actual authors of state law. So this is about as far away as we can get from the way much of the literature equates legal pluralism with folk law, with ethnic or religious minority populations, or with jurisdictional boundaries between local, national, and supranational law. Dueling law also confounds one of the radical legal pluralists' central tenets, their critique of the hegemonic pretensions of the nation-state and its class of legal experts, who tend to get described as hell-bent on imposing unitary codified state law to the exclusion or subordination of other popular, marginal, subaltern conceptions of law and justice. This is clearly not what's going on here at all. Another way that this focus on the procedural legalism of dueling confounds the scholarly literature on legal pluralism is that the need for this particular form of non-state law applied, remember, to crimes against honor over which state law did in fact assert jurisdiction. It was justified almost exclusively in terms of efficacy. It was argued that dueling law functioned more expeditiously than state law and provided superior outcomes in terms of the kind of justice achieved and the norms communicated by law. The argument was that the honor code provided not retributive justice, but restorative justice, that it was less adversarial and more geared toward the mediation of disputes. Now, when I say less adversarial, I mean, I'm surprised didn't laugh out loud. I mean, for what could be more adversarial than two men facing each other with swords or pistols? But actually, I hold to this assertion because the seconds were charged with working as conciliators, and even combat itself was imagined as a reconciling ritual of restorative justice, which advocates saw as more satisfying than the punishment-driven adversarial process that an accusation of libel in the courts would spark. So again, to reiterate, while most of the literature on legal pluralism and non-state law focuses on folk or customary law, or on the needs of minority populations, indigenous peoples, here the only rationale for the existence of non-state dueling law was that it worked better than state law did, or it was believed to, at least in the eyes of people who were intimately involved in the writing and interpretation of that state law. So finally, the last point, interlegality. The concept of legal pluralism posits the coexistence in any given society of multiple forms of law, governing actions in multiple fields of social intercourse. The concept of interlegality deals with what happens when those different systems of rulemaking come into contact. One way to understand the concept of interlegality is that it's not much different from the idea of transculturation, when non-state law and state law, or different forms of non-state law, or different levels and jurisdiction of state law interact with one another, they mutually influence and change each other. In some ways, the idea of interlegality is the logical, inherent, inevitable corollary of legal pluralism, and therefore may not even deserve to be treated as a separate concept. Because if different legal orders coexist in a single society, obviously they don't inhabit completely self-contained spaces. As one scholar puts it, interlegality is just basically a dynamic approach to legal pluralism. Dueling provides a brilliant case study in interlegality, going both ways. And this is, again, the last point that I'm going to go into in this talk. First, I've already mentioned how the dueling codes adopted the structure and language of formal legal codes. This makes a great deal of sense because so often it was the very same people who used and even debated and wrote both forms of law. But this is not what most interests me because it's intuitive that duelists would seek to cloak their criminal code violating actions in every trapping of legality that they could muster. What interests me more is the influence in the other direction, the ways in which the norms, principles, and language of the honor codes infiltrated and changed nation-state law. Simplest example to start with, first of all, is that the criminal codes of Spain, Italy, Argentina, Uruguay, and several other countries define the crime of dueling in terms that only make sense if you understand the dueling code's own core principles. Here are some of the dueling provisions of Uruguay's 1889 criminal code. So the penalties will be substituted for homicide or assault when the duel takes place without the intervention of seconds. When the weapons, or when there's deception or violation of conditions agreed to by the seconds. Punishment will be diminished when it's submitted to the decision of a tribunal of honor. The same principles held true for the Argentine, the Spanish, and the Italian criminal codes, written all roughly at the same time. The exception was the French Penal Code. France did not treat dueling as a sui generis crime, but instead applied the articles on murder and assault. Or I should say, didn't apply those articles because in France as well, impunity was more common than prosecution, at least in the later 19th century. And because state law in so many countries defined the crime of dueling in terms borrowed from dueling's own codes, and that make no sense if you don't understand the principles of the dueling codes, dueling manuals ended up actually being employed as expert testimony for points of interpretation in state criminal courts. So this is the easiest example, but there's more complicated examples. Dueling advocates sought in several countries to invest honor tribunals with the authority of state law in dealing with allegations of crimes against reputation. One of the first efforts of this nature was again in Italy, according to Stephen Hughes, where Paolo Fambri, in his 1869 book Jurisprudence del Dueling, proposed creating national honor tribunals as obligatory courts that all gentlemen would swear an oath to submit all their personal incidents to prior to any duel. Fambri's idea did not bear fruit on a national scale, so he failed to achieve his desired elevation of honor tribunals from dueling law to state law. But there were more limited successes in establishing obligatory honor tribunals within specific institutions, within the armed forces particularly, but also within the journalistic profession, thus endowing these tribunals with a limited degree of quasi-official authority. But a really interesting point is that on several occasions, opponents of the duel also sought to incorporate into state law the institutions of seconds and honor tribunals. The idea was to preserve, expand, and formalize the conciliatory mechanisms of the gentlemanly honor codes, while repurposing those institutions away from actual combat, which the anti-duelists, of course, wanted to abolish. This is precisely what the anti-dueling leagues, organized in the turn of the century across Europe, led by the Spanish royal Don Alfonso de Borbón, it's exactly what they proposed. Reforms to nation-state law that would render the duel unnecessary, but would do so by incorporating key elements of dueling law into state law. It seems to me that these men believed that the swords and pistols part of the duel was the problem, a barbarity out of step with the progress of their age, yet it was a barbarity that stood atop a system of dispute conciliation that they agreed was superior to that offered by the law of the nation-state. And this particular formula ended up being proposed in the draft Spanish Criminal Code of 1908, which never ended up getting approved but was seriously debated. The identical formula actually made it into law in post-revolutionary Mexico as part of the 1929 Mexican Criminal Code, though the December 1929 code was short-lived, replaced in 1931 by a new criminal code that eliminated that particular reform. The pinnacle of interlegality along these lines was Uruguay's, finally back to Uruguay's 1920 law that decriminalized dueling. I won't go into all the history of legalization, in part because I've already been up here for a significant amount of time, and also because it's covered in my book and flyers are available. But two key points support the thesis of this talk. First, the argument for legalization was expressed in terms exactly like Rivarola's in Argentina. It was all about how the generalized legitimacy of dueling law and the dead letter illegitimacy of the state criminal code that made dueling a crime had the effect of bringing all state law and the officers who enforced it into disrepute. This was a quote from the author of the legalization law. Periodically, our judges remember the law against the duel exists. They make 1, 2, 3 attempts to enforce it. Later, they give up, comprehending that it's absolutely impossible to make these laws effective. Can one say that it fortifies the dignity of the administration of justice, that it favors public order, that it moralizes society to maintain laws that compel judges either to become objects of derision and ridicule in the eyes of the public, or to fail to fulfill the duties that their office demands that they execute? It's a long quote. The next guy said it much more succinctly. So, legalization was therefore designed quite explicitly, as you can read in the parliamentary debates, to end the existing situation of legal pluralism and to bring Uruguay under the rule of a single law for everyone. Secondly, the August 1920 dueling law, the legalization law, did not actually repeal the provisions of the 1889 criminal code that defined dueling as a crime, but rather it declared that the penalties established by that code would not apply in the case of any duel that received the approval of an honor tribunal. In so doing, Uruguay's 1920 law, like the 1908 Spanish proposal and the 1929 Mexican criminal code, brought the institution of the honor tribunal, a creation of dueling law, into the realm of nation-state law. What distinguished Uruguay's law from was that in Uruguay, honor tribunals retained the power to authorize duels, and it made those duels legal when so authorized. The text of that 1920 law was then later incorporated into Uruguay's 1933 criminal code. It became Article 38 of that code. All of this is the definition of interlegality. And a final example that I would be fascinated to look into more, though I don't have the language skills, involves, of all things, Germany's anti-hate speech laws. In a fascinating 2000 piece in the Yale Law Review, James Whitman argues that the primordial inspiration for Germany's unique legislation criminalizing anti-Semitic slurs and other similar insults comes indirectly from dueling law, and that aspects of that legislation, such as provisions defining grades or levels of insult, read as if they were plagiarized straight from 19th century honor codes. Whitman's explanation is that the precursors of Germany's post-World War II anti-hate speech laws emerged at the turn of the 20th century and had roughly the same inspiration as the Spanish Criminal Code proposal of 1908, this proposal coming from the anti-dueling leagues and Alfonso de Borbón, namely the effort to ban dueling while at the same time preserving and importing into state law the conciliatory and restorative elements of dueling law. Or at least that's how I read Whitman. So, to conclude, finally, what constitutes law? Are nation-states the only source of rules that can be called law? I'd say that in this presentation I've embraced a fairly strong version of legal pluralism, but in fact you don't need to take a radical law is everywhere and everything is law position in order to see dueling law as actual law. The duel may be a really strange place to look for legal pluralism and interlegality, but I hope you might find the examples I provided convincing, or at very least not boring, despite the absence of good swashbuckling anecdotes. Thanks.